I've been one of those people who kind of have hung on to the notion of doing attorney meetings. I'm finding myself having to convince lawyers to do it, but nearly every time they are appreciative of the way it gets done. And what I'm doing it these days is more active, where I'm involved in kind of sharing, because I've heard from both sides, what I think are the main positions of each side, and starting the conversation.
The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. Welcome back to Mediator in the Middle, a podcast about mediation by mediators for litigators, lawyers, their clients. I'm your host, Abe Melamed. I'm a mediator specializing in helping parties resolve complex business, employment, and tort disputes in California, New York, and Arizona. Today, we are really honored and excited to have our guest, Gig Kyriacou. I got that right, Gig?
Yes, perfect.
Okay, good. Gig is, really just a phenomenal mediator in California. I think he may have the highest statistic of the number of cases he's been involved in that I've seen, over 6,000 cases he's been involved in resolving. He has, he's been recognized by his colleagues as having a keen ability to absorb, analyze, and distill complex information. He's been an attorney since 1984. Can I say that? Am I dating you too much, Gig?
No, it's okay. I have a daughter now practicing for 6 years, so I can't.
Oh, wow. So you can't hide it anymore. But, Gig really is, for those who don't know him, he was recognized as the best lawyer in America many, many years. Los Angeles Magazine recognized him as a Southern California superstar. He's one of the top neutrals in the Daily Journal. He's, really just accolade after accolade. It would take the whole episode to just go through them all, but very experienced, very knowledgeable about every possible mediation process that there is, and we're really excited to have him give us a little bit of insight into the topic for today, which is to basically focus on conducting executive sessions or attorney meetings or anything like that. But let me start first by welcoming you, Gig. Welcome. Thanks for being here.
Thank you for having me.
Of course. It's my pleasure. Did I miss anything in the bio you want to add?
Oh, I don't know. Just that I love what I do.
Fair enough. Well, we'll make sure that people see the link to the actual bio. But no, we're really excited. You have a wealth of knowledge. And the quote that you said at one point when we were prepping for this was "lower your voice to be heard." I thought that was just such a phenomenal quote, really to epitomize what the topic is. And that is, during mediations, attorneys have an opportunity, if a mediator will give it to them, to have a session together with each other, with the opposing attorneys, to discuss the legal issues, the merits, the facts, whatever it might be. And that's really the focus, is just how to do that. Really, that attorneys or that mediators should be doing it more often. But let's start with that. Anything right off the bat you want to mention about that process?
Well, when I first got trained back when, 95, I think. And by the way, there are other mediators like Krivis and others who've done as many or maybe even more mediations than myself. But when we first got trained, we were trained on doing a full-blown meeting of counsel and clients and engaging the other side. I was one of those guys early on who saw that there was great risk in doing it that way, that people often pointed fingers, insulted the other side. We would spend hours trying to get back to even. And so I was an earlier adopter of doing the joint sessions between attorneys and having meetings with the attorneys to talk about the case. As we're evolving and, with consumer demand, more and more mediations are going on without any kind of attorney meetings or any kind of joint involvement. And there are times when that might be appropriate. I have a few lawyers that I work with that I just can't trust. They can't trust themselves to be in the room with the other side.
Sure.
So I'll do it that way if the parties give me a good reason and and the market is getting more in that direction. But I am concerned that we're losing a great opportunity to put the attorneys together to talk about the case, but not only talk about the case, but to build rapport with themselves, build some levels of trust so that we can engage in this process in a way that brings about positive settlements. And so I've been one of those people who kind of have hung on to the notion of doing attorney meetings. I'm finding myself having to convince lawyers to do it, but nearly every time they are appreciative of the way it gets done. And what I'm doing it these days is more active, where I'm involved in kind of sharing, because I've heard from both sides what I think are the main positions of each side, and starting the conversation.
Get it started. So I was going to actually ask that. That would be the perfect place to start. How do you go about doing it? What's your process? Take me from when you're discussing this with the attorneys to the actual session. How do you run your process?
Well, unfortunately, I don't do a lot of pre-mediation calls. The schedule's just that busy.
It's a good problem to have.
Yeah, but I think it's a great idea if you have the time.
Sure.
And the parties are far enough along to have a meaningful discussion. I have found that the attorneys are also awfully very busy. And if I talk to them 3 days before the mediation, they are not focused. So what I've done is I'll take the time before we do any kind of joint meeting to talk to each side. And, over time, people learn your style. So, yesterday, the one side had a client who wasn't going to be able to stay the whole day. I ended up spending 45 minutes with one side before I even engaged the other side. I texted the other side a heads up, this is what's going on. But sometimes if you can have that conversation, you can learn a whole lot. And by the day of the mediation, they are focused. So, but there are many occasions where attorneys will call me in advance and they want to clarify an issue or a problem, either with their client or with the other side or with a carrier or something. And I think that's a great idea. So if an attorney does have an issue that needs to be addressed in advance, by all means, make contact with the mediator. I will get on the phone whenever I can to have that discussion.
Sure, and that's a theme that came up a lot with the episode with Jan and with Lee J, is that preparation if you can get it. But I think that's a really important nugget for lawyers who are listening to this, because that's what this is all about, is helping them help us, is make sure to pick up the phone and call Gig if you have something you need to talk about.
Right, and talk to me, bring it up. Don't save a problem with the carrier or a problem with a client until it arises during the course of the mediation. Give me a heads up so that, I'll be able to work with you during the day and figure out the best way to help resolve it.
That makes sense.
Sometimes, attorney will need the mediator to address a client issue right at the beginning. Client's nervous as hell, is worried about having to confront the other side. It gives us an opportunity to say, hey, you don't have to get in the room with the other side, Zoom or otherwise, virtual or otherwise.
Sure.
So, and then, we can learn a lot as mediators from having that initial conversation with a client who is fearful, angry, distrusting. Those are things that if you'll give us a heads up, we'll be able to deal with at the appropriate time. So sometimes the best time to have that conversation with the client is after they've gone through the process and they're trying to make a decision about, the final number. Sometimes you have to give it to them over the course of the day. Sometimes they may need to address the other side. So then you right. Strategize about how you're going to have them do that. You don't want the client exposed to the whole day with the other side or to the other side's arguments at times. But you may want the other side to see the pain that the client's going through, and they're very convincing. They're an A+ witness, an A witness.
Sure.
And you may want to present them if they haven't had their deposition taken. So again, that I encourage attorneys to strategize. Strategize with me. Let me help you. Some of my best ideas I stole from the attorneys. There's
Sure.
a whole social science aspect of reactive evaluation, they call it. I don't like labels, but basically what it means is,
Because you have to label it.
yeah, people tend to discount what they hear from their opponent, heighten what they hear from their side, and a neutral they trust.
Right.
So if you've got a good idea, it's better if I buy into it that I present it as opposed to you present it to the other side. So a lot of times we talk about things like that. We strategize. That's
The strategy of how to do it.
throughout the whole day.
Right.
Throughout the whole day. And sometimes you have to, there's nuances. Sometimes the strategy is just not to go back right away. The other side
Right.
took an hour to make a move.
Got to twiddle your thumbs.
Yeah, you
Yeah.
can't go back in 2 minutes.
Yeah.
At that point in time. So there's just different things you have to be aware of.
You got to constantly change as the day goes on. And I think that's a good point about kind of a joint session with everybody. I think that's something we've talked about that, most mediators have done away with, especially in serious cases, sexual harassment cases, things like that. But, having an opportunity to evaluate someone, that's something some people have started to do in cases that traditionally were only in PI as a victim impact video. Let the adjuster see a short video of this person describing it, let them assess and evaluate how they'll be as a witness. But the joint session, I think, I view at least as a rarity. I ask the parties, do you want it? But I will only do it if both sides agree to it. The executive session, I think, is maybe something that's a lot more valuable. And I think, I want to hear your thoughts on when you think it's best and, how to go about structuring it. But let's start with that. When in the process do you typically find it's most beneficial to put the lawyers together? Is it typically early on? Let's just try to strip down to what the actual issues are. When do you do it?
So I do it after I meet with each side, find out if there's any issues I'm going to be dealing with that day. There are times where I may spend a little more time. Yesterday was an example where I spent a little more time going back and forth before I brought the attorneys together, but it typically is at the beginning. And I explain to people, I want to have a conversation. This is not to win your argument. I just want to make sure each side knows where the other side's coming from. It also helps the mediator. It corroborates what the mediator talks to the parties about after that. So if one side kind of lays out their case, the other side lays out their case, when I go to talk about the other side's case privately with the one side or the other and their client, they've already heard the other side present it. At least the attorneys have heard.
Right.
Typically, they've kind of briefed their clients on it before I come in to help walk them through it. And what I try to do at that point is I'm honest with what they just heard, but giving them a view of a third party, helping them evaluate the strengths and weaknesses of their case. And then it has more credibility. I have more credibility. They don't think I'm blowing smoke about what the other side's saying because they heard it. So
Right.
You're building up the process as a party, as an attorney representing a party, by going through that process. It also gives you a chance to meet the other side and engage the other side. And, when there were times where doing a full-blown joint session with the clients in the room worked, but it really required skillful attorneys. There was an attorney named Steve Maloney, and he allows me to give him credit for his approach. He would always want to meet with the other attorney and their client. And his approach was, he would tell them that I've only heard my client's side, and I really want to hear your side. Because I know there's always two sides to something, and it bought him so much credibility with the other side that it helped skip steps ahead on the trust level. And, one of my mentors, Bill Levin, he was a senior partner when I started practicing law. He was also a snoop. He used to come around the office and look at the in and out boxes. And I had written a position letter on a case, and it was 10 pages long. And he says, "You can't send this letter." He pulled it out of my box and read it. He says, "You can't send this letter. It's way too long." I said, "Well, it was 17 pages. I cut it down to 10.
It is a brief, yeah.
Anything you have to say, 2.25 pages.
Yeah.
Like, "Bill, I got to get this pleading out." He grabbed it. An hour later, he came back with a 2.25 page letter that said what I said in 10 pages better than I did. And he said, "I left out one sentence." And I said, "What's that?" He says, "I want you to tell me." So he gave me like another half hour, and I couldn't figure it out. I was busy. And I said, "Bill, I'm humbled by your letter. It's, first off, your writing is terrific. And second off, the fact that you could say 10 pages in 2 pages better than the 10 pages, I was impressed." And he's, after he punished me for a little bit, he basically said, "Tell them you've only heard your client's side, and tell them, go have a cup of coffee with them or a bite to eat once you're at the courthouse." He says, "Engage the other side." He said, "If you do that, they will reciprocate, and you'll create a good relationship, and you'll be able to solve a client's problem." And then I saw it in action with Judge Maloney now. And when Judge Maloney was appointed to the bench, he called me up, and he said, I wish I saved the voicemail. I erased it somehow, but he said, "Gig, over the years, you and I have mediated 40 or 50 cases together." And he says, "I want you to know our record will always be perfect." He said, "We settled, I don't know that you know this, but we settled every one." And I said, "Really?" And he said, "Not all first day, not all at the mediation, but we followed up, you followed up, I followed up, and we got everyone settled. So now our record will always be perfect." And it was such a sweet message, but it was so telling of his skill as an attorney.
To continue that process.
Yeah. So that gets lost if you just tell the mediator, carry messages back and forth. And the attorneys know their case better than the mediator. We try to focus like a laser beam the day of the mediation, the days before the mediation. But there's always a nuance. There's always something that isn't in the brief that the client may or may not have even told their attorney, that you can find out through the process.
Right.
And that's why I think it's very important. And you get an opportunity to kind of, stick a hand out, shake the opposing counsel's hand, so to speak.
Without the bravado, you don't need to kind of put on the show of bravado in front of your client that you might otherwise need to in the room too. I think that's a huge value. Is I always, at any point as a litigant and now as a mediator, at any point when we're doing this, usually the jacket's off or the tie is off. It's kind of more of a relaxed conversation. And, being able to distill that, I'll tell you the old, I think it's a Mark Twain quote was, "I'd have written a shorter letter, but I didn't have the time." Yeah. So that's what it's all about, is distilling it. And that, I think, is a great segue into how you structure what you would, I guess, allow or advise the attorneys to do in that, because it's not going to be productive if they sit there and they speak out a 10-page brief. It will be productive if they sit there and they home in on, whichever one of those is the correct saying, on the real meat and potatoes of the case. So how do you like to set that up in the actual room with those lawyers?
So, this is where it requires work for the mediator. You really have to know their briefs, and you have to spend some time preparing, and you have to show them that you've done that. The worst thing people hate as a lawyer is they wrote a great brief for the judge and the judge didn't read it.
Never read it, yeah.
It's the same way with mediators. You've got to do your preparation. And more, because more and more are not liking these joint meetings, I try to turn them into just a simple conversation where I find it my responsibility to start the conversation and to keep it going. And you can think about in a party where, you're kind of the host, you have a duty to kind of keep that ball
moving along.
Right. And what I try to do is my mind works chronologically. So I try to walk through whatever the scenario is in a chronological fashion. I will quickly summarize the broad picture, but then I'll tell them, look, guys, part of what you do is you pay me to help evaluate the risks, the strengths, and weaknesses of your respective cases. So these are the key issues that I see. If you think there are more, please bring them up. And I will go through and kind of help them analyze, ask questions about meetings that took place, that are part of the fact pattern of the case, or legal issues, and I'll identify, and I'll try to get them to agree what the dispute is.
Right.
So, and what the key factors of the dispute are. And sometimes it's just a matter of, whether an event occurred, or there are different perspectives of an event that everyone agreed occurred. And we'll talk it through. And, lowering your voice to be heard, came from an attorney, David Wimmer, Swerdlow, Florence, et cetera, Wimmer. We were doing one of those full-blown joint sessions. The clients were yelling at each other, and it was like everyone talking and yelling at the same time. And he put his hand up. He says, well, what I think we're dealing with in this case. And everybody, what? And they all leaned in. And he had it. He simply had it, because they were all talking and no one was listening. But he lowered his voice and everybody leaned in and was listening. So he controlled the room.
Right.
And I think it was a great example of him paying attention to what was going on, not adding and making it worse, but subtracting and making it better. And, there's a study on communication, the Morabian study, which says 55% of communication is body language, 38% is tone, only 7% of communication are the words we use.
Yeah.
And so, in doing this long enough, I use the phrase listening with your eyes. And part of listening with your eyes is reading the room. And people say, well, how do you do that in the age of Zoom? And I said, well, it's not as easy. You're not seeing everyone's body. You can't see if their legs are crossed, or maybe even if their arms are crossed, but you can look at everybody at the same time. So there are distinct advantages with Zoom where you can only
and
look
an
at
up close shot too, usually.
Right.
Not across a boardroom table.
Right. So that's what you have an opportunity to do, and you read the room and you figure out what they might be willing to listen to at that point in time. You may have 3 or 4 arguments, but they're like acknowledging one. They're acknowledging, hey, there may have been a little bit of retaliation here. Now remember, they know their case from the other side. So you may be picking up cues that you would never have gotten had you not gotten in the room with the other attorney.
Right.
And, there's another phrase I use, concede your way to settlement. The first party that makes the most credible move now controls the negotiation, because they're now credible. The other side is required to reciprocate. There we go again, with, Cialdini's, he wrote a book, Science of Influence. And, 2 of his main theories, fundamental concepts of human nature that he talks about are the principle of reciprocity and the principle of liking.
Mm-hmm.
And both of them work in mediation. You engage in bad behavior, the other side reciprocates. You engage in good behavior with your members, with making concessions about any issue, the other side's obliged to reciprocate.
Reciprocate in the same way. Yeah.
In the old West, people wouldn't say thank you. They would say much obliged.
Mm-hmm.
But what that meant was they were now, you did them a favor, they're now obligated to return it. And if they don't, their behavior is what's wrong.
Yeah. And if you're not engaging the other side, to be a partner in getting this resolved, it's not going to happen. There's no, their client's not in the room. It's just them.
Yeah.
You don't need to beat your chest or anything.
Yeah. And it's confidential. So it's very
Yeah.
safe. And it's an opportunity, to get a sense of where the other side's coming from, what issues they find important, how you might be able to address their issues. You didn't think one of their issues was very good at all because you have facts that discount their issue, but they think it's great. Well, now you're able to, hey, John, I hear what you're saying, but, let me show you something. Here's an email. Here's a text message.
How are you going to respond to that? Or how is the jury going to see that? That's, that to me is what I always found. It's what mediators told me when I was a litigant. It's what I see as a mediator. Is I always found the most effective joint sessions like that with the attorneys were where both sides respectfully, not in an adversarial, angry way, presented to the other side almost as if it was an opening to a jury. So instead of being adversarial, it's more like, let me paint you a picture of how I string together these series of facts and these pieces of evidence to show you why I think you need to pay me more. And then you have your opportunity to do the same thing. And then we can kind of talk after that and nitpick at each other's little points. But I think that a lot of times the lawyer on the other side doesn't see that cohesive picture from the view of the person on the other side. And this is an opportunity to see it. And
there may be a reason to legitimately hold something back. You're not sure if the other side's acting in good faith.
Yeah.
And early on in this process, people say, well, I don't want to give them free discovery. And I'd look at them with kind of
that's foolish. Yeah.
So you'd rather pay tens or hundreds of thousands of dollars to litigate through discovery?
Yeah.
Be at this place, 6 months from now? If you can have a good 30-minute conversation, you can learn 90% plus of your case without going through expensive discovery. And that's what makes mediation so valuable. So why give that up as an attorney?
Yeah.
And by the way, if you create that relationship that Bill Levin, my mentor, wanted me to create with my opposing counsel, it's how I ended up getting in mediation, because I engaged so many opposing counsel. I was able to resolve disputes.
Discovery disputes, whatever it might be, you get in the habit of that. Yeah.
And, it encouraged me to get involved in the field even more. And then I went and got some training, and then I did some volunteer work, and, I'm now doing what I love at the same time being able to help people. My son's a physical therapist, and, I'm a little bit jealous because I've used physical therapy in the course of my life. And I always admired how, no matter the age of the patient, there was always a great conversation. There was always a smile, and you got to help them get better.
Yeah.
That's the opportunity as an attorney, as a mediator, we get to do for our clients. They've been stuck in a mess for months, years. I've had cases that went over a decade. And this is a chance in one day to solve their problem and give them the freedom to move on.
Yeah. But we do help people. It does make a very big difference. And I think that the mediation process is what really advances that cause. And so I want to pivot for a second into kind of the converse side of that same piece, which is, what don't you do, or what should you not do? What would we tell lawyers who are listening to this not to do in a mediation? And obviously the easiest one is just don't yell at the other side. Don't get angry. I had a mediation once when I was a litigant where the defense attorney came in and just started yelling and pounding the table, and mediator called an end to it and pulled me aside and said, I don't know what his problem is. I don't know what side of the bed he woke up on, but that was inappropriate, So that obviously you shouldn't do. But are there other things in terms of subtle digs or passive aggressiveness or things like that you think it's important to tell lawyers, don't do this in that sort of an attorney session?
So what I tell lawyers, if I think it's going to be a problem, and obviously the great thing about doing what I do over a long period of time is you get to work with people who are good, like your style, and want to use you for your style.
Sure.
So, but I tell lawyers to think of the other side as their jury. Do you want to offend the people you're asking to pay you a lot of money, or you're asking to take less and try to settle the case? You wouldn't go and point fingers and yell at the jury or give them a stink eye or anything like that, right? That's what.
Not if you want to win anyway.
Yeah, I tell people as a mediator, as good as you might consider me, I don't decide your case. So trying to win your case by demeaning the other side doesn't work. And I think the most important thing you can offer, because it requires reciprocation, right, is to listen to the other side. Very early on in my mediation career, I came across this article called The 10 Commandments of Good Listening. And it was written by a guy named Keith Davis. Don't know much about him, but it was so brilliant to put it in this phrase, that they are commandments. Because the first commandment, you want to guess, to good listening, is to stop talking. And lawyers often have a hard time to talk.
Be quiet and sit down. That's the old phrase.
Yeah, I mean, and you don't listen to rebut, you listen to hear.
Active listening, yeah.
Yeah. So, and these are not unusual things, whether it's in a conversation with, someone you're close with, or in a litigation dispute. There's nothing to be gained by doing the talking. You already know what's in your head. You want to solicit what's in the other person's head, what's in their heart, what's driving them. So the first commandment and the last commandment to good listening is to stop talking. And, I'll make jokes of it at some time, hey, you're violating the 10 commandments of good listening, just as a joke. But it gets people's attention, because the first thing you have to do is to stop talking. And then show them you want to listen. Don't get on your phone while they're talking.
Right. Don't be distracted.
Yeah. Don't, and I fight this at times too, because I like to take notes in case I want to ask a follow-up question. But you gotta make that eye contact. You got to, basically show them you're really listening.
Yeah.
As a mediator, we do this because we come prepared. And when they talk about a meeting, you might pick out the date. You're prepared. So you say, hey, are you talking about the meeting on July 27th? The one at this location? If I can insert that, they know I'm listening to them. They know I'm paying attention.
Yeah, they know you're prepared.
Now I have credibility. As the opposing counsel, you can do that as well. And the best lawyers in negotiation are the ones who will concede an issue, concede a fact.
Yeah, that was going to be a big point that I have highlighted in bold. Concede some points to get some credibility.
Yeah, and do the Steve Maloney. Empathize with them. Tell them you've only heard your side, and they have a different perspective. I did a case once early on in my career, and it was eye-opening. It was a bus ran over somebody in a wheelchair out in the street. And there were 5 eyewitnesses and a camera in a liquor store that was taking a picture every second. I got 6 different stories, and none of them were biased. There were people that, it had rained the night before, and this poor gentleman who had polio was riding every day. He took his motorized wheelchair to the liquor store to buy a pack of cigarettes. And on the night before, it had rained, and he didn't want to do the disability ramp because it was going to get all wet. And so he stayed in the street. And a bus driver was near school, and kids were coming to school, and the bus driver was running late on his schedule and turned a corner, and, it was over. And what I learned is, even when people are not biased, their own values, the angle they're looking from, they get a different perspective. So we have to respect that. And I think if you respect the other side, again, they'll listen to you then. And that's, as mediators, what we want to facilitate.
Yeah.
While we're evaluating, we're facilitating.
We're also facilitating the.
Yeah.
No, I there's a grid I don't remember if it's in Getting to Yes or Difficult Conversations, but there's a really great grid that I think laid it out, and I'll just use one example. Was a landlord and a tenant, and the tenant is thinking, I have long days, I just want to go home and relax, and why is this landlord always banging on my door and bringing me pies? And the landlord's thinking like, I can't imagine how hard it is for him to work so hard. I want to bring him. And the tenant's thinking, how could you raise my rent? Inflation, and I can't afford it. And the landlord's thinking, I have inflation too. I need to raise the rent. And so it's the same facts, but two very different perspectives. I think 100% active listening, any good marriage therapist will tell someone that is listen to hear, not to respond, and to understand the other person. Try to at least put yourself in that person's shoes.
In some ways, it's very simple. But when parties are engaged, emotional, somebody wronged them, somebody's trying to take advantage of them, they're not hearing.
Yeah.
If you as the mediator, if you as the attorney can have a conversation, it may be difficult, Sheila Heen's book, but it's very important. And ask questions. Everyone thinks they know it all when they come and they know their client side and they know a few things on the other side. But if you have a conversation, so much more comes out. And I've been surprised many a time where I thought the case was about one thing and it turned out to be about something very different.
Yeah.
Or it was, it was about one thing, but one party or the other was stuck on something else. And until you work through that, you weren't going to get anywhere.
Yeah, it's like polling a jury. That always blew my mind. You finish a trial, you poll the jury. Why is it that you gave my client millions of dollars? Well, I really like that tie you wore. Why is it that you found in favor of the defendant? Well, your client scowled once when someone said something, and you're like, the expert testimony about the gunshot residue didn't change it. Nope, that wasn't what I was thinking. So you got to listen.
Yeah, I've been there. What juries hear during the course of a trial and what they decide on, oftentimes they get it right. I think they get it right most times. But their rationale for getting it right, it makes you scared.
It always shocks you, yeah.
Yeah, that's what makes mediation so valuable.
Yeah.
Because
you have control.
Yeah, you can get rough justice in a mediation without incurring that time, expense, and emotional grief.
And risk.
And lack of productivity for that period of time.
Yeah.
I tell people, and this resonates a lot with plaintiffs. My experience in representing parties in litigation was the party feels like they're in purgatory.
Mm-hmm.
They want to go forward with their life. They want to be productive. They want to put this in the rearview mirror, but the litigation requires them to keep looking back and addressing what's behind them. So they get stuck in the middle and their life's on hold. And a lot of times as attorneys in this process, it's our job. We don't pay attention to that,
Yeah.
Litigation,
we kind of have to keep them focused on the past as opposed to on the future.
Right.
Yeah.
And litigation is not scary to us as litigators. We've done it long enough. So we sometimes ignore, and that's part of the problem with attorneys as well. They have to take the temperature of their client.
Yeah.
If a client doesn't want to move forward, then you got to figure out a way to get a deal done.
Yeah.
If the client is looking for way too much or offering way too little, you have to use the process to help you. Use mediators, use us. And this all comes out in those early discussions before we do a joint meeting with the attorneys, or during the course.
Or a call if you can.
Yeah. Or a follow-up to that meeting. You want to use the mediation process to learn as much about the case as you can, good and bad, right? Because it's going to come out. Good lawyers are going to ferret out, their best case by the time they get to trial. So try to pretend that's not going to happen it's very remote. Now,
it's naive.
Again, Yeah, you may have
It happens. It happens. There are outliers. I can tell you stories, but it's rare.
well, if you have a declaration from a key witness and you don't want to let the other side know, then hang on to it.
Mm-hmm.
Tell the mediator that, I don't want this shared. But if you get close to settlement and it will buy you more in your direction, and you're about ready to settle the case, then use it.
Yeah.
Take advantage of it at the end.
I've even had some times where we got to the point where it hinged upon a key witness statement or something like that, and we made the settlement contingent upon that being produced.
Yeah.
So now if you produce it, settlement's consummated. But that's actually a great point also, is it's a great opportunity to exchange documents. One of the big discussions we had with Lee J when he was on the podcast was about the fear that lawyers might have about exchanging documents. California, fortunately, has a really strong privilege, but there might be some fear about exchanging documents or information. You do it in a joint session, even on Zoom now, and I want to shift to that for a few minutes before we have to finish up, but even on Zoom now, in a joint session, I can throw something up on a screen share, or one side or the other side can. The other side's not taking pictures. You would know if that was happening on Zoom, and you have an opportunity to show it to them, not just to kind of shuttle it through the hands of the mediator to them. So, I don't know if you have any thoughts on that, but it's a value, yeah.
Yeah, no, I think part of that's the reason why I think the attorney meeting is important. If you build a rapport and you build, one side's not the only one sharing information. And the way I particularly do it, I actually walk through chronologically and I put each side's position each step of the way. On this meeting, this is what plaintiff feels happened. This is defense perspective. Here's a couple issues that I'm curious about. Did this happen or that happen? Yesterday, one of the issues was, whether the employee had gotten prior notice, and they had not shared information. And defense had an email showing that the person wasn't just fired. 3 months earlier, they're saying, we have to take care of this issue. It was a safety issue. You need to address it. So that was eye-opening for the plaintiff. And what they thought was this 22-year employee got fired for one event that they didn't have.
Out of the blue.
So by getting the defendant to share that information, we were able to put the settlement together.
Yeah.
If I wasn't able to share that information, I would have never gotten the plaintiff side down to the range
to where they ended.
Yeah, would attract the defendant to keep talking. And, early on, a lot of times you get those cases, they're way too high, they're way too low. That's why I think that conversation is important, that analysis.
Narrow the gap.
Yeah.
Yeah.
Because, I used to do environmental cases, and the plaintiff's lawyers would always say, this is the worst environmental issue, and the experts are going to say this and this. And the other side would say, the experts are going to say, no, that's not a problem. That's like a spit in the ocean. And then the plaintiffs come back, no, it was like a beached whale. And I'm like, I'd like to talk to the experts. And I suggested I talk to the expert alone, and the lawyers freaked out and wanted to be there. And I said, okay, we're going to set up ground rules. You can be there, but I'm the one to ask questions. You guys cannot talk.
You don't get to ask questions, yeah.
And I asked the expert questions, and they went from 90 and 10 to about 45 and 55 in terms of the
numbers,
and the range of issues. So we were able to distill a lot down, and things got easy after that. So it's easy to posture when you're telling a mediator or a third party your case and calling the other side's, ridiculous, and they do the same back. But if you're in the same room having the same conversation, you're going to have to kind of pick up that some of your points are not going to hold water.
Right. And if you concede those, if you concede it to the other side and they reciprocate, you also kind of build that rapport and that trust with each other to try to shift to have a real conversation of the numbers. And, so which actually is a great pivot point to another topic. And I don't want to take too much more of your time, but who do you think should be in these meetings? That's a question because, sometimes if it's a key document that's being exchanged, if it's getting to, hear the cohesive set of facts, the insurance adjuster, it might be valuable to have them in that room. Sometimes you might have a conflict where you've got an adjuster having a different interest than a party, or you might have multiple parties. You have the harasser and the company have different counsel. In your view, what's the best way to structure who should sit in that room in that attorney meeting, so to speak?
So this should be handled by the attorneys before they get to the mediation.
Mm-hmm.
They want to find their best representative for the company. They want to try to work out any insurance issues or narrow them. If the insurance carriers were expecting the plaintiff to contribute because there's uncovered claims, at least address it before you get to the mediation. Know what the issue is. And
Right.
then we can talk about whether it's appropriate to have the insurance representative in that meeting with the attorneys. Typically, most of these guys are now attorneys themselves.
Right.
So they're both
Yeah.
attorney and client. And in some respects, like you said, they may have an adverse interest to their own insured. So you want to address those in that pre-meeting before I put them in the room. Typically for me, it happens on the day of, but with lawyers I work with all the time, I tell them to address it beforehand and let me know if there's an issue. So, and you also want to talk about is if there's a chance my client's going to be in the room with the other side, what the heck are they wearing?
Mm-hmm.
Talk to them
Sure.
about
Dress code and
what you're expecting them to address and not address if they go in the room with the other side. I typically try to orchestrate any joint session that involves a party, because I don't want the party to feel like they were had in that kind of meeting.
Right.
They lose trust in the process, lose trust in the mediator. They may even lose trust in their own attorney. None of that's good to the process. So I will try to walk through. I also tell the attorneys and the parties, if they're going to be in this kind of meeting, that I may ask a question that you don't want to answer in front of the other side. You just say, Gig, we'd rather talk to you about that in private, even if you don't want to talk to me about it in private. Just say that.
Just say that.
That's my cue to back off.
Right.
So I'm not going to do something that you don't want to happen. For me, I have to maintain credibility with both sides the whole time through. And there are times when I will take risky opportunities to point something out, but at the same time, I'll try to do it on the other side as well. It's very important that everything can't be one-sided. Now, that being said, the facts may be one way or the other, and it's not a 50-50 compromise. It never is in a mediation. So you have to walk through the pluses and minuses, and you try to make people feel comfortable that you're not going to abuse their trust. And
Right.
then you show it as a mediator, you have to show it. I mean, and attorneys have the great thing about mediation now, there's good mediators across the board,
Mm-hmm.
right? They have different styles, and the attorneys have become, sophisticated consumers of the process.
Of the mediation process. Yeah.
So they know who's right for a particular case.
Right.
And if they can get that mediator or someone, has a similar style, that's who they're going to target. And by and large, with a number of good mediators now that exist out there, they can get a good mediator for their case, for their clients,
Yeah.
for what they're dealing on that day. If you want a screamer and a yeller as a mediator, I just tell people that's not me. And as we were talking,
Who is it? No, I'm kidding.
well,
We don't have to name names.
No, I mean, Romero kind of cherished that reputation.
Mhm.
Judge Romero was,
Judge Romero, yeah.
he was such a character, and people loved him. And he would throw the F-bomb out every third word, but
Yeah.
people knew kind of what was in his heart, and he was great at what he did. And if you needed that for your clients, some people needed.
Sometimes you need it.
Retired
Yeah.
judge who would drop F-bombs. They loved him. And there are mediators who are, touchy-feely, and for certain cases, you might need that.
Yeah.
My particular view is it's much more art than science.
Mm-hmm.
It's much more
It's
nuanced.
intuitive. It's
Yeah.
nuanced. Yeah.
You know, they taught us that you can be evaluative, you can be facilitative. I think you can be evaluative and facilitative in the same paragraph.
Yeah.
You know, in the same meeting. You got to be strong sometimes. You got to help parties really understand a bad fact, but you can also empathize with them with their
Mhm.
situation and understand that this is impacting their lives.
Right.
And so, you know, if you'll have that honest discussion, if you'll be yourself, and I tell lawyers the same thing, look, you don't want to see the ungenuine gig. I don't want to
You
see
want your authentic gig. Yeah.
plaintiff lawyer or defense lawyer. Let's just have that conversation. Let's surround a possibility of settlement. Let's talk about it. If we get into a range of reasonableness, we'll figure it out. We'll find a way to settle it because the alternative is far worse.
Yeah.
Let's just work
And
together.
that's what mediation is. It's just understanding the alternative and making the right choice based on your options. Yeah.
And I tell people, look, I want to have a conversation. It's my job. I'll get it started and we'll keep it going. And, you know, even when we think it can't happen, then we can talk about how we can make it happen in the future. And I did a case last week and both sides, I tried to explore whether I could do a mediator's proposal, kind of gave both sides a potential range. Both sides said, yeah, don't do it. I said, okay. I said, but look, here's your issues. Here's your issues.
Mm.
I'll follow up with you in a week. The week didn't go by where each attorney called me and said, hey, Gig, my client's given it some more thought. You know, maybe a mediator's proposal is not a bad idea. You know,
Now's a good opportunity.
You know, can you push it? Can you push it a little higher? Can you push it a little lower? And I said, well, now you can tell why I'm proposing this. They both said they're going to recommend it. I'm confident it'll be done.
That they're going to take it.
Yeah.
Yeah.
So, you know, there's a whole phrase about the right answer at the wrong time is still the wrong answer.
Mm-hmm.
So again, as mediators, as attorneys, we need to know when to push, when to hold up, what to strategically will work. You know, a lot of times it's not the numbers, it's the verbal message that's important. You know, at the beginning of the day, you know, we talk about this in the mediation world. How do we get people to start with more reasonable, you know, opening demands and first offers?
Just talked about that. Yeah.
Yeah. And it's a story that will go on into the ages. Some people just don't trust the process. If you build that trust, if it takes an extra meeting or two with the attorneys, you can do it that way. Over time, sometimes I'll say, guys, do you really want to do this?
Mm-hmm.
You know, can we skip the insult round?
Can we get to the real numbers? Yeah.
Yeah. Give me your third demand and your third offer. Let's talk. Sometimes that'll work. Sometimes their clients just have to see it fail.
Right.
Sometimes one side or the other doesn't have authority, you know?
Yeah.
So if you try to push that square,
which is a game in and of itself that the adjusters often play and not giving the authority or, you know, but yeah.
Right. And so if you build trust, if you have that conversation, if you get people to, I tell people, you know, you start at insult and go to outrage and then very unreasonable. If you just get to unreasonable, we'll settle this case.
That's all it takes is get to unreasonable, and that's
get to unreasonable. You know, get away from outrage, ridiculousness, and get to unreasonable, and I'll help you settle this case.
I like that.
Once you get to that point, there's too much at stake.
You got to at least give it a shot. Yeah, the analogy I always use is let's stop playing checkers and start playing chess. You know, checkers is one little piece at a time, and chess is strategic. This is where I'm headed, and these are the several moves I'm going to do to get there. So,
yeah, and I often use the phrase three-dimensional chess. I'm with you, but you know, chess might be the law, another dimension might be the facts, another dimension might be the emotional issues. So you're like keeping your finger on the move, checking out. Okay,
gotta look to see.
Yeah.
It's like poker and chess combined. You got to watch to see the reaction of the other side when you but you're playing touch chess, so don't pick up your finger.
You don't pick up your finger until you're sure. And now with Zoom, you can look at everybody.
Yeah.
You know?
It's a great advantage. I don't want to get into it too much because you've already given me so much of your time, but I think that's That's something that I've learned, and I'm sure know better than many others because you've done so many throughout the pandemic. But being able to have that up close view of people, if you're going to occupy your mind with what their mannerisms are and body language and things like that, you get a chance to. So it's nice.
It's just having a conversation that at one time can be personal, another time can be strategic, another time or all at the same time, be educational. That's what makes this process so incredible, that you can take on a lot and distill it down to a face-to-face conversation with people, and you help them solve their problems.
Yeah.
And
that's why I've got all the Rubik's Cubes in the background. It's all about solving that problem.
Right. And if you, as the mediator, another thing I say often is, that's my job. Have you ever been to a mediation as an attorney and the mediator says, that's not my job? What the heck are we paying you these outrageous rates for? It is our job. It's our job to kind of figure out, but if we can distill it down to a simple, friendly conversation, it is adversarial. There are dynamic interests on both sides, but it doesn't have to be one way or the other, my way or the highway, because you've got to consider the alternative. And if the alternative is far worse, or, on any level, economic, emotional, productivity, you're not doing anyone favors. And I know that there's a lot of, maybe 10 years ago, there was a big discussion about, is our role as mediators to settle cases, or is it just important that we bring the parties together to have a discussion, so they know they got
transformative
day in court? And I call BS to that. Parties are coming to mediation and paying a lot of money because they want to either settle their case or understand that,
or find out it can't be settled.
Find out that the best offer is not acceptable.
Right.
People that end mediations early, to me, I'm always curious as to why an attorney would walk out of mediation without knowing what was the best possible deal. And I think that's the job of the mediator. And
it's to get to that end result. The thought I had earlier today when we were doing the IAM session was that so many mediators use the phrase, you're going to have to compromise today. Both sides will have to compromise. A good mediation is when both sides. I think it's actually no. You're the smartest person in the room for yourself here. You're the client. You're going to make a smart decision.
Right.
We're going to get to decision time where you'll have to make the right decision for yourself. Forget about the other side. It's not about compromising with them. You're making the right, smart choice for you, or not. Hopefully you're making the smart choice, but maybe that choice is not to settle.
And you don't want to walk away until you know what the best deal you can get.
Yeah, until you're educated.
Not doing their job if they can't get you to that point.
Yeah.
And I said that a couple of weeks ago to the parties, and then I realized they were like way too far apart. There wasn't authority, but we spent the rest of the day getting it lined up, and they're coming back in a couple of months. And
That's great.
It's
going to happen.
If they're willing to do that work, then they're invested in the process. At a minimum, you get them invested in resolving the case as opposed to litigating.
Right.
And
get the ball rolling on that.
So,
anyway. All right. Well, I don't want to keep you. That was a lot of time and a lot of information. The last question I always like to ask, though, is just, what is your favorite part about being a mediator? What do you find most rewarding?
It's just the fact that you get to help people solve problems at a very difficult point in their life. And what they've been living with for months or years, they can resolve in a day. And the end result of that is you literally see people going from being nervous, angry, to a sense of relief coming over them.
Yeah.
And you see a lot of times when the lawyers have fought really hard, and they finally come to a deal, they literally, mostly figuratively, but I've had literally
shoulders roll back and
they will embrace the other side.
Yeah.
I had a partnership dispute where they were like fighting with it. We had to separate them on floors. And at the end of the day, they were talking about, once we settled the case while we were drafting up the agreement, they got together to their own attorney's chagrin, but they were talking about each other's kids.
Yeah.
And I'm glad
Yeah.
we got this done. And, I'm going to see you at the synagogue and we don't have to look away from each other. And how's
Yeah.
how's
Getting
Mary
to be a
doing?
part of that process is it's pretty special.
And I can't tell you, as an attorney, I got one nice letter or card a year. As a mediator, I get it often.
Dozens, yeah.
Now they happen by text usually or email, but I often get cards or letters, and people tell you, so happy we got this resolved. I want to thank you, and they don't need to thank us. They pay us a lot of money, and we love what we do. But that's probably
But they appreciate it.
nicest.
I love it.
What we do.
I love it. Well, I appreciate you taking the time. This is my chance to express that gratitude to you. It really has been a pleasure. You're extremely insightful and clearly experienced, and I hope that's helpful to the listeners to get a little better of a sense how they can be most effective in mediation and use this process of the attorney session, executive session. So, thank you, Gig. Really appreciate it.
Thank you. Thank you very much, Abe.
Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. Thank you.